Hi, everyone. So today we're going to talk a little bit more about the trial process. And what we've talked about so far is jury selection and then with opening statements. And so those are some of the first steps of the actual trial. And this next step is where the prosecution is going to start to begin to present their case. And so what we call when the prosecution starts to present their cases, we call this direct examination. So they might have 2 witnesses, 10 witnesses, 20 witnesses, but each time they are bringing a witness up to the stand to question them, that's called direct examination. And so what's going to happen is we're going to watch a quick video clip right now. And this is one of the opening scenes of The Hangover, that movie, if you've ever seen it. And so what I want you to think about is after watching, how do we find out what on earth just happened the night before that scene that we just watched? And what sorts of questions should we ask? So let's take a moment and watch that.
No one knows how much I love you. No one knows how much I care. But when you put your arms around, I feel so hard to bear. You give me fever. When you kiss me, fever when you hold tight. Fever. Fever all through the sun lights up the daytime, moon lights up the night. I light up when you call my name, 'cause I know you're gonna treat me right. When you kiss me, fever when you hold me tight. Fever. Sister.
Okay, so now that you've watched the film, you're probably thinking, okay, well, I want to know what happened the night before. And so the types of questions that you should ask are the who, what, where, when, why, and how questions. So first, what day is it? Where is this? What happened? Why is there a chicken, roaming around your hotel room? Why is there a tiger in the bathroom? Right? So what you're trying to do is asking questions that will make the witness tell a story. You do not want in direct examination for them to ask questions that are yes or no. You want them to elaborate. So when I say, why is there a tiger in the bathroom? They might say, well, I don't really remember why there was a tiger in the bathroom, but come to find out, we actually kidnapped the tiger from Mike Tyson's property, right? You want them to be able to elaborate. So that's very important with the direct examination questions. Then the defense has the opportunity to question the prosecution's witness to try to poke holes in it. And that is called cross-examination. And so the best practice here is to use yes or no questions during cross-examination only, because you want to not let them elaborate because you're trying to poke holes in their story. So let's think about this. During the cross-examination, the attorney is the star. They want to command the attention of the judge or the jury. The witness has already had the attention of the judge or the jury, right? They've already been questioned and told their story. But now it's time for the attorney to really make sure that they are poking holes in the argument. I know I'm going to say that a bunch of times, but that's the best way to say it. Now, they want to get into a rhythm with the witnesses so that they're doing exactly what you as the attorney want them to do. And you want to use leading questions, as I said, to build upon questions from before. So let's use this next example. So if we were in class, I would say, okay, you're with a partner here. Your partner just said that they had a crazy weekend. All that they could say is that somehow they wound up in Mexico and they think they might be the proud new owner of an exotic animal of some sort. So pretend that you're the witness's best friend and you want all the details. What kinds of questions would you ask, right? So if you're your best friend, you'd be like, oh my gosh, how did you get to Mexico? When did you get back? Wait, where in Mexico did you go? What do you mean you're the proud new owner of an exotic animal? Like, what animal is it? How did you get hold of that animal? And you're going to ask them all these questions that get them to tell a story. Now, that would be in a direct examination scenario. Okay, so part one, I was just directly examining the witness. Now, part two is now I want you to take on the role of the angry parent. And they just found out that their teenage kid somehow ended up in Mexico and is the proud new owner of an exotic animal of some sort. So they are confirming all the things that the witness had done wrong. So that you think about an angry parent, they're going to say, I'm sorry, you're telling me that you went to Mexico and then you got an exotic pet? And you're saying that you got this exotic pet on the black market? And you paid for it with cash from your savings account that your grandmother contributed to, right? And so those are all yes or no questions. And during cross-examination, you can see as this angry parent, I'm leading you in the direction to show you that you've done something wrong. Whereas your best friend is like, oh my gosh, give me the details. And so I want you to kind of think of direct examination versus cross-examination in that way. Now, the prosecution might call up, let's say 5 witnesses. And so they're going to do this for each witness. First, they're going to directly examine them, the prosecuting attorney, and then they're going to sit down and the defense attorney will get up to cross-examine. Then witness number 2 will come up. The prosecuting attorney will do the same thing where they'll directly examine and ask those who, what, where, when, why, how questions. And then the defense attorney will come up and ask the cross-examination questions. And that's going to go on for as long as we have prosecution having witnesses. Now, the defense then, after the prosecution rests, is going to come up and do the same thing. And in this case, the defense is going to directly examine their own witnesses to get them to tell their stories. And then the prosecution will be up there to cross-examine. Okay, so it goes both ways there. So let's talk a little bit about evidence, because there's lots of different types of evidence that can be presented at trial. So typically the rules of evidence are in case law and are in statutes, laws themselves like that are legislated. And all evidence, though, must be relevant, competent, and material to the case, and that's very important. Now, during a particular witness testimony, so let's say you have a police officer who's investigating the crime that has just occurred. Let's say it's a murder. All right, so the police officer is going to get up there and explain, well, I was called to the scene on such and such a date. I found the victim there. I realized it was the victim because their license was in their pocket, right? They're going to go through their whole story. Then maybe they come to the part where they say, well, did you find anything at the scene? And the police officer is going to say, well, yes, in fact, I did. I found a knife, which I therefore cataloged as evidence, seeing that the victim was in fact stabbed many times. And so at that point, the prosecuting attorney is going to say, Your Honor, I'd like to submit this into evidence. And so they're going to take the knife like in a plastic bag and they're going to show it to the judge. They're going to show it to the defense attorney. And they're going to say, detective, was this the knife that you were just referring to? And the detective is going to say yes. And they're going to say, well, can you tell me where you found this knife? And so basically they're using that evidence as they tell that story. And so they need to build that foundation. They need to make sure that the witness recognizes it and is able to ask questions about it. And then thereafter, after they're done sort of with that evidence, then they're going to take it and say, Your Honor, I'd like to submit this as Exhibit A, or whatever it is. So that kind of evidence is called demonstrative evidence. It's real evidence that can appeal to the senses, right? It's apparent to the senses, right? Something that you could touch, see, hear, smell, that type of thing. Now, some evidence sometimes might be competent and relevant and material, but could be excluded because maybe it was prejudicial, maybe it's inflammatory, or perhaps because it was collected in a way that, violated the defendant's rights. Perhaps it violated the Fourth Amendment and it was, taken or seized illegally, right? Now, the kind of evidence where the witness actually gets up on the stand, this is called testimonial evidence. It is still evidence, but it is evidence that is obviously heard in this case, right? And so there's different types of witnesses. There's, of course, victim witnesses. So somebody who perhaps was assaulted might get up on the stand to tell the story of how the assault happened. You could have eyewitnesses, and these are people who were there. They saw what happened, or they heard what happened, or something like that. And then you also have expert witnesses. Expert witnesses might be people that aren't exactly or seem to be involved with the case, but might be an expert, for example, on tire tracks, and perhaps tire tracks were found at the scene of the crime. Or perhaps they might be an expert in emergency room trauma, and they might actually testify to the kinds of wounds that were on the victim's body or something like that. Now, no matter what kind of witness you are, all witnesses have to swear that they will tell the truth. And if they don't, they could actually be prosecuted for perjury. Now, the defendant does have the right to testify, but sometimes that's not always the best idea. Sometimes putting the defendant on the stand can actually be really troublesome, because it could mean that they give up a detail or they say something that could really hurt their case. And so the thing is that as a defendant, you have every right to not testify as well. The prosecution cannot make you testify. And that is because that's a constitutional right. You have the right not to incriminate yourself. And so it's really up to your lawyer and you to decide whether or not you as the defendant should really testify, because again, sometimes it's not always in your best interest. Oops, I already did that one. All right. There's one other kind of witness that I haven't talked about, and this is a character witness. This is a person that's going to testify about the defendant's character. And they might, bring up, I don't know, Johnny's school teacher who says, Johnny was the nicest kid I've ever met. I can't ever see him murdering his best friend, right? And so they're someone who's supposed to testify that this person was of good character. Now, the prosecution can, of course, call that into question, meaning that they can ask someone to testify against the defendant's character, like that they were, in fact, a bad character. But the prosecutor can't begin this line of evidence. The defense has to prove first that they're showing a character witness, and then the prosecutor can, in fact, do the same. Now, there are some things when it comes to witnesses that are very important, and this is called hearsay. And we're going to talk more about this with objections. But this is when testimony is made in a trial or pretrial proceeding that is offered as testimony, but the information is secondhand. So let's say you have Sally, and Sally did not witness the case, right? She wasn't there when this person was murdered, but she said, well, my friend Billy told me that Johnny admitted to doing it. That is not okay, because that's secondhand, right? We don't know that to be factually true. And they did not have direct personal knowledge or experience as that testifying witness. So hearsay is not acceptable. And again, we'll talk a little bit more about that with objections. Now, there's another sort of part of this evidence that's very important too. As I said, direct evidence is that demonstrative stuff, right? Where an eyewitness testifies what they saw, heard, tasted, smelled, or touched. Now, circumstantial evidence is evidence that could be inferred from a fact or a series of facts. So it's not necessarily in your face, but for example, let's say that Johnny, the person who's on trial for murder, let's say that somebody gets up and is a character witness, and they say, well, Johnny was a really great guy, but he was fighting with his friends a lot in the weeks before the murder. And then they might say, well, what do you mean he was fighting? Who was he fighting with? Who was he friends with? And they say, well, he was friends with the victim. And so they're not really saying outright that, of course, Johnny testified or seeing or hearing or tasting. It's sort of inferring, like, oh, you're inferring. Okay, well, it seems like Johnny, in fact, might have been mad at the victim beforehand, right? And would that make sense? It kind of leads you in a particular direction with what that witness is saying. All right, so when it comes to objections, what can happen sometimes during witness testimony is that the other side could have a problem with perhaps the evidence that you're providing, perhaps your line of questioning. And so they can stand up, or, obviously we'll be doing this potentially virtually as well, and say, Your Honor, I object. And what I like to see during our mock trials is I want you to explain why you're objecting. I want you to say, objection, Your Honor, the counsel is leading the witness, or objection, Your Honor, hearsay. And that just shows me why you're objecting. Now, certain states actually require that you explain why, and certain states don't. In Massachusetts, you actually don't have to say why you're objecting. It's sort of expected that you know why you're objecting and that the judge will know why as well. And so the judge can decide whether to sustain it or overrule it. So if they sustain it, they mean, okay, yeah, no, you're right. I agree with that objection. If it's overruled, they're like, no, I don't agree with that objection. We're going to continue with this line of questioning or continue with this evidence. So if the objection involves a question that is posed to a witness, then the judge can actually tell the witness not to answer the question. If they already did, though, the judge could tell the jury to disregard the answer unless it is so prejudicial, meaning it just prejudices the jury so much against the defendant that the judge could actually declare a mistrial. Which, remember, a mistrial is a trial that is invalid and it cannot stand. So there are lots of different kinds of objections, and I'm going to go these kind of quickly, but I'd like you to, of course, make sure that you have these written down and you are expected to know them for the mock trial coming up. So leading questions are questions that suggest the answer that the attorney wants. So these are usually more yes or no questions. And these are not allowed during direct examination. They are allowed during cross. I cannot say that enough. They are allowed during cross. So you cannot say, is it true that you locked the door when you left the house? Objection, leading the witness, because that's a yes or no answer. Instead, you could say, what did you do, if anything, when you left the house? Or even, what did you do next? Then we have questions that are considered argumentative. You could also sometimes hear a lawyer phrase this as badgering the witness. And this could be perhaps maybe you have a hostile witness, maybe you have a difficult witness, and you rephrase the question or you find yourself getting frustrated with them. And this, of course, could mean that the other side could object that you're argumentative or that you're harassing or badgering the witness. Speculation is where it requires a witness to guess. So if you, for example, were to ask the detective who is, investigating this case, could you let us, who do you think perhaps killed the victim? No, objection, Your Honor, that's speculation. They're not supposed to be there to tell you who killed. They're supposed to be there to tell you how they investigated the crime and how it led them to the arrest of the defendant, right? So one example here is, would the driver have had time to slow down if he saw the light turn red? Objection. That's speculating. But you could say, where was the driver when the light turned red instead? Now, narration happens way more than you think, particularly on the first days of mock trial. And this is where the questions are not broken up enough. And so you might ask a witness, where do you work? And they might go on and say, well, I went to college to be an architect because I got a job as a business consultant after graduation because my father knew the owner. And I didn't like it very much, so I quit when I met Jessica, who was a real estate developer and a really good friend. And so we decided to go into architecture business together because I have an architectural background. And so we call it Cool Living Designs. And as you can see, I'm just going on for like a paragraph, right? So instead, if I were the attorney on the other side, I would be like, objection, Your Honor. And so instead you could say, well, where did you go to college? Or what did you go to college for? Okay, now what happened when you met Jessica? And they would say, well, I quit and I decided to do something else. So what did you decide to do next, right? So you want to break up the question because you want them to still tell a story, but you don't want them to narrate. Now, relevance is a pretty easy one, and this could be that maybe the question posed is not relevant to the case or to at least the understanding of the case. Hearsay, I already talked a little bit about this, but this is any courtroom or any statements outside the courtroom that are like a he said, she said kind of thing, right? So objection, the bartender told me that the driver had been drinking all night. Objection, Your Honor, hearsay. Instead, you could say, what did you witness with that driver? And you could say, well, I saw them having 7 drinks at the bar that night, right? And so again, that's not hearsay because that's firsthand witness testimony, whereas the bartender telling you something, in fact, is hearsay. There are some exceptions to hearsay, and this could be, for example, a statement made about the event that demonstrates the intent of the speaker. So for example, this is admissible. So quote, after he got out of the car, the driver said, I'm sorry, I didn't see the light turn red. right? Or it could be a statement made by a party in the case that it goes against his or her side. So what is admissible? You could say, well, the next day the driver told me that she'd been texting her boyfriend, so she didn't see the light. So that is hearsay, that is acceptable. Hearsay, I will let you know straight out. Practiced, seasoned lawyers, if you ask them what is the one objection you have the hardest time with, still, even after perhaps being a lawyer for 20 years, they're going to say hearsay. In fact, I've heard many lawyers say, oh gosh, I don't get hearsay. And in fact, I've heard judges say, oh, hearsay is the worst, because there are some exceptions, but it's hard to figure out which of the exceptions and which are not. So if you think you're going to object with hearsay, try it out and see if it works. It may not always, but you could try. Now, also, you can object to firsthand knowledge. The witness must have directly seen, heard, or experienced something, right? So objectionable. Everyone has been talking about how the driver ran the red light and caused the accident. What could be better instead is you say, I saw the light turn red while I was in the intersection. The driver was about 100 feet behind me, and a few seconds later, I heard a huge crash. That is good and okay because you saw and you heard something, rather than what about everybody was talking about. Opinions are almost always objectionable unless it's a qualified expert witness. So, for example, if I am a doctor and I am on stand to show the particular kind of stab wounds and how they might have occurred, you could ask me, in your expert opinion, how did this person die? And I could say, my expert opinion, they died from major blood loss due to the stab wound in the upper left cavity of their chest. Right? And that's okay because I'm an expert. And of course, you cannot ever ask, like, do you think that the driver committed second-degree murder? No. Again, that's an opinion. They're not there to offer an opinion. Witnesses aren't. They're there to offer you the facts. Now, there are some things that are beyond the scope of the cross-examination. So I didn't actually mention this earlier, but you can direct exam. And then, of course, let's say the prosecution is direct examining, and then the defense is cross-examining. Let's say something came up in cross-exam that the prosecution is like, crap, I didn't think of that, or I wish I need to clarify that, or I want to ask this witness more questions. The judge can say, would prosecution like to redirect? That means that the prosecution can get up and ask a few more questions of that same witness. However, they are limited to the topics that were discussed in the cross-examination. They cannot just bring up new things, okay? And then after they redirect, you can actually have a recross where the defense could get up and recross again if they would like. But again, that is limited to what actually occurred in the redirect. Ooh, I'm going backwards. Now, beyond the scope of the packet is really just for us. That's like, you can't embellish what's not in the packet, everyone. Like, I know it can be fun, but we're supposed to sort of stay with what's in there. And so the other side can object if you're like going above and beyond what's in the packet. Now, when to object? Well, you can object when an attorney is questioning a witness, like literally in the middle of a question if you want. You could object when a witness is giving an answer, again, in the middle of the answer. And you could also object when an attorney is admitting evidence. So if they're admitting, as I used the example earlier, a knife, then you can object during the admitting of the knife as a piece of evidence. And how you object is you stand up and you say, Your Honor, objection, and you state why. You state that it's hearsay or badgering the witness or whatever objection you have. And so you could say, as an example, objection, Your Honor, the witness is narrating, the attorney's question has already been answered. Now, we don't, of course, this is virtual, so we're not going to practice making objections. But if you are an attorney for the mock trial, we will practice making objections if time permits during class itself. Now, after we've had all the presentation of the evidence, meaning we've had the direct exam of the prosecution, cross-exam of the defense, and then, of course, after the prosecution rests, we're going to have the direct exam of the defense and the cross-exam for the prosecution. Then we have what we call closing arguments. Now, remember, in our opening statement, you weren't allowed to be argumentative. In your closing, you are. Okay, very important. It is okay to present an argument. So this is your chance to sum up the case, to kind of give a little bit of a recap on all the evidence that you presented and the witness testimony you presented. And you are going to do this in a way that is most favorable, of course, to your side. Now, again, just like in the opening statement, you can't go too far. Like, don't tick off a jury, don't tick off a judge by any means. So they are not like opening statements. You are arguing the facts that came out during the case, okay? Because perhaps you weren't anticipating that some piece of testimony came out during the case, and it did, and it totally helps your side. Well, then you are going to want to bring that up. And so the prosecution will typically present their closing argument first, and the defense goes second. And there's really no objections made during closing. I usually, for our mock trial, say no objections. Like, I just want you to be able to say it without any. And it's pretty rare to have objections during a closing argument as well. Now, remember that the purpose of the closing argument is that, like I said, an argument. You cannot argue in the open when you're questioning witnesses. You can't argue with the judge. So you're telling the jury why, after all this evidence has come about, your side is the clear winner of the case. And you can do this in a few different ways. You can use the evidence to your advantage and show them why this evidence, which is totally spelled wrong right there, sorry, makes sense, and why their evidence perhaps doesn't. You could show them why your witnesses were more factually accurate, why your witnesses were more credible, or perhaps maybe they saw the scene better than their witnesses. And you can pull out specific pieces of testimony. You can say in your closing arguments, well, you heard from the detectives today that in fact they decided to arrest the defendant because of blah, 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 right? And you can actually almost like pull out sort of quotes, if you will, from the witness testimony. Now, there are errors. I'm going to leave this up here for a moment and not go too much into this. And this is just because if something is super prejudicial, or that it could actually cause a mistrial. As I've told you before, you can't say that the defendant murdered the victim. That is not okay, because that's too prejudicial. It makes the jury think automatically that this person is a murderer. So you cannot phrase it in that way. If you were to, bam, mistrial. And that has happened many times before, particularly with new attorneys. There are some harmless errors as well. And these are errors that sometimes are not sufficient enough to really stop the trial from happening. Now, a quick word on defenses. This is what the defense attorneys might use, I don't want to say as an excuse, but as rationale for why the defendant may have committed the crime or should be excused from the crime. So it could be due to infancy, meaning perhaps a young age. It could be because they were intoxicated at the time, and this could be intoxicated like drugs or alcohol. It could be because this happened in a period of duress. So let's say, for example, that they were emotionally upset because of something that just had happened and they committed a crime, right? It could have been involuntary. It could have been entrapment, that perhaps the police or some other person had entrapped them into doing this. It could be due to public duty, legal impossibility, self-defense, or the defense of others. Maybe they were acting under the authority of the law. Perhaps they were insane, although we don't really call it insane anymore. Usually you hear it like the mental incapacitation or something like that. Like, for example, there have been cases in which somebody was found to be mentally ill and in a schizophrenic state when they committed a crime, and therefore shouldn't be excused for the crime. They still, committed it perhaps, but that should be taken into consideration when you're thinking of punishment. So, for example, rather than going to prison, they might send that person who's going through a schizophrenic state to a hospital where they can receive treatment, right? And they can make sure that they are psychologically okay enough to stand trial, even in the first place. Now, after closing statements and those few quick words, usually if you have a jury trial, the judge will then instruct the jury on what the law was. So if it's a first-degree murder case, they'll explain what first-degree murder kind of is and what standards they need to meet to make sure that beyond a reasonable doubt, that person has committed first-degree murder. Now, sometimes there's what they call a directed verdict, which is when there's a finding that there's insufficient evidence to convict the defendant, the judge might direct the jury to actually come back with a verdict of not guilty. You cannot have a judge, though, ordering them to come back with a verdict of guilty. That is that is illegal. Now, the judge must clarify to the jury what they should be doing. And so if, for example, the defendant is charged with first-degree murder, but the law also permits them, like maybe first-degree murder, all of the standards weren't met, but the law in some states allows the jury to decide, but second-degree murder, the standards were met. Then the judge will need to explain that to the jury, that you can do one or the other in certain circumstances. Now, I know I've said this a lot in class, but I cannot stress enough that every defendant is innocent until proven guilty beyond a reasonable doubt. And so that's why it's so important not to say, for example, that the defendant murdered the victim. No, because they're innocent until they've been proven guilty, right? And beyond a reasonable doubt, we have talked a lot about now with 12 Angry Men and watching that. But this is the standard of evidence that's required for conviction. This means that there's no uncertainty at all, that the facts would lead to a reasonable person to conclude without a question that the defendant committed the act for which they are charged. Now, after the jury goes into the deliberation room and talks about whether or not the person is guilty, they come back out, and then the jurors will come up with the verdict. In Massachusetts, they actually permit people to take notes. In some states, they don't. So the jurors can take notes while they're actually watching the trial. But in Massachusetts, after the trial is over, they actually are ordered to destroy all of the notes after the verdict has been read. And so, as we know, juries can sometimes deliberate for hours. Sometimes it can be days or weeks, to be honest, if they're having a really hard time with a particular decision. If they don't reach a verdict, they call that a hung jury. And they might go back to the judge and say, Your Honor, I'm sorry, we're a hung jury. And the judge usually will be like, nope, go back in the room, talk it out some more. And that can happen sometimes a few times. It's pretty rare that a hung jury will be like the sort of end of the case itself. Now, a not guilty verdict, of course, the defense might ask for an acquittal at that point, meaning that the person is cleared of all charges. And if they're guilty of the crime, then usually sentencing will happen later, but the defense might ask for a new trial if they feel that something went wrong with this particular one. And sentencing hearings are separate. Usually the defendant won't be sentenced right at the end of their trial when they hear the verdict. And that is it for today. Thank you for watching. And as always, let me know if you have any questions.